This is docket 9818 CE100, the application for a CPCN of Ursa Solar for authority to construct the Langdon Mills Solar Electric Generation Facility. This is Mike Newmark, Administrative Law Judge for the PSC. And we're here on a motion hearing from the applicant to strike portions of the Langdon direct testimony and exhibits. I called the hearing in order to expedite the process because we do have rebuttal looming in the not too near future. And also witness Tan had requested some additional time to file a response. And I thought instead of going through the paper process and waiting for me to file an order, we could just take care of this as quickly as possible. So we do have the motion on file. And we need to hear Langdon's response as well as we can hear responses from other parties. And I did issue an email that notified you of the hearing that provided a bit of guidance as to what I saw may be relevant for the hearing, and also some other matters we can discuss in order to facilitate the process in an efficient manner. So actually want to get those emails up in front of me as well. Still people joining us, so that's good. Great. Okay, so I did want to hear from witness Tan about the particulars of the motion. I think what might be useful just as a preliminary matter is to kind of get more clarity on the legal standards, because I did have some questions about the citations, the case that the applicant had cited as grounds for striking the testimony. So just, I think maybe to get the law clear first, and then we can hear sort of the particulars about the Langdon's response, and also particulars on individual portions of the testimony that's subject to the motion. So okay, so I did mention in our email, the first email in this that called for the hearing, that I did have some questions about the applicant's citation to Walmart Stores Incorporated versus Labor and Industrial Review Commission. It's 2000 Wisconsin App 272, and that the applicant had used that citation to provide the standard upon which to evaluate whether evidence may be presented by a lay witness or must be presented by an expert. That's at least how I read it. Maybe I'm not reading that right in terms of your argument, but just like some clarity about that, and also to know whether, I mean, I think my initial read of this is that I believe Walmart Stores spoke to, and it was a case in that reviewed an administrative hearing and a decision, an agency decision. I think it spoke more to the fact that what's the nature of the evidence that's required to create substantial evidence in order for an agency to rely upon to make a decision, rather than what evidence the agency can accept on the record and then review in order to make a decision. So so that distinction is critical here. And if the applicant has any more information to kind of shed light on that, I'd appreciate it. So why don't we start with that? Okay, I'm not hearing you. Is that Attorney Callisto, are you speaking? It looks like, yeah, you're mute. I can unmute you from here. Maybe that'll the process here. So, okay, so you're unmuted now, and
Can you hear me now?
yeah, and I think
Okay.
gonna unmute Alex as well.
Okay.
Okay,
Sorry.
great. Yeah,
Just
no,
give me
go
one
ahead.
second here. Thank you, Honor. As you noted, we studied a number of cases, and I assume we're going to walk through these directly. Let me speak to the Walmart case first. I think you've raised it here as relevant to the commission's statutory obligation to make a determination on individual hardships under 196.491. And I believe the case stands for the proposition that if those individual hardships are claimed based upon matters that require expert knowledge to substantiate, then the case is absolutely on point. There are a number of issues, as we noted in the motion, that we believe require expert witnesses to support real estate valuation, medical opinions, impact of the project on wildlife, how glare will impact Ms. Tan's property, noise, etc. And Walmart, and the quote from it to start the case, is that special knowledge or skill or experience on subjects which are not within the realm of the ordinary experience of mankind and which require special learning, study, or experience are those that require expert witness testimony to prove up. Ms. Tan is not a medical doctor. She's not an expert on land valuation or an expert on solar projects, including glare or noise, not a land use expert. But those are the claims she's making that she says lead to her individual hardships. The Walmart court found that the plaintiff had not shown causation when his employer fired him because of an outburst that he had at work. And his claim in challenging that termination was that he had obsessive compulsive disorder, and that was what led to him being fired. And the court there said he needed an expert to show that causation, the cause between his termination and the reason for his illness. And the same is true here. We believe that Ms. Tan needs an expert to show how any of these technical topics cause her individual hardship. These are not the kinds of topics, using the language of the Walmart case, quote, that are within the realm of the ordinary experience of mankind, end quote. It doesn't matter that the commission is not a lay finder of fact in the classic sense. The Walmart court said that medical and scientific fact is, quote, not one of employment policies or practices, end quote, that were used by the administrative body that made the determination there. And our position is that the same is true here. Glare, noise, property valuation are not things that the commission, through its general knowledge, can opine on without the assistance of an expert witness. In the words of the Walmart court, for the commission to rely on that without expert support, quote, would be speculation. Scholarly articles without expert testimony don't give the basis that is either necessary. Ms. Tan's not an expert in any of these areas, as I've noted, and that was something that the Walmart court pointed to as well. In that case, the plaintiff can talk about what he believes, but they can't make the ultimate conclusion on causation. And she's trying to show through her testimony and some of the documents that she proposes that the issues she raises are going to cause individual hardship. I'm not questioning her ability to talk about her general beliefs, but when you start going down the path of putting in scholarly, what appears to be scholarly conclusions or technical conclusions and scholarly documents, that is the realm of expert witness testimony. So that is our response to the Walmart case.
Okay. Any of the other attorneys have comment on Walmart and its applicability? No.
Your Honor, we just would note that we agree with applicants' take on this and the distinction that Walmart made with the expert requirements for the types of testimony that intervener tone presents.
Okay. Okay. So, okay, I'm glad I got that clarification from the applicant about the applicability of that case. But at this point, I think it's useful to get witness Tan's response now that we have that clarification, get her response to the motion. And so let me just let you take it away there, Lauren, and give us your comments. You need to unmute and then go ahead.
So in regards to the documents that I've cited, those are self-authenticating documents. So they are scholarly studies that are available to anyone to read. And I am not saying that I am an expert on that particular subject matter, but I am able to access those documents, read them, and draw conclusions from them, and question the matters that are brought up in them to the PSC in regards to, for instance, property value. So when it's in a peer-reviewed journal, it's my understanding that that's a self-authenticating document, and I don't need to be an expert to cite that or reference that. Also, a lot of the things that are put in my testimony, I'm not claiming to be an expert on, but I am making observations as a witness myself. I live here. I see the areas that are being affected. I'm smart enough to conclude patterns, and especially like animal behavior. Like I have sat here for 4 years to watch the geese fly in and out. So to tell me that I'm not an expert is fine, but I can still draw conclusions based on patterns, which I don't think an expert needs to do. I just feel that if you are going to require everything that an intervener such as myself tries to draw as a concern for the PSC to look at, needing expert opinion, you're taking away some of the voice of the people who are trying to intervene in the process. You know, like I said, I've never claimed to be an expert, but I am trying to use reliable, credible documents, documentation and research to show things that are of question to me and other people throughout the community. So the applicant can feel how they want, but I am just trying to make observations, and I'm trying to find as credible as documents as possible to help the PSC see where my points of view are coming from.
Okay. Now we do that. There are a number of places where the applicant wishes to strike your testimony, witness Tan. I think in your response, I would have expected to see a response to each item. Do you have a response to the items that they're wishing to strike, or you just want to make a general response?
I do, if you'd like me to go through each one individually.
Yeah, I want to give you that chance. Yeah, now I can put on the screen the items and the testimony, citation, and the objection, the chart that the applicant had provided in the motion. So let me do that if it may help some people anyway. So this chart actually I had modified to include some of my own notes, but I'm not going to share those on the screen at the moment. So let's see where I just lost the video here. Okay, now I see everybody. So yeah, so just direct me to the items, and I did add an item number just for convenience. I just numbered them sequentially on the first column. So if you have comments on item 1, go ahead and we can just go down the list.
Item 1, I'm not going to speak on much. If the applicant feels that's hearsay, that's fine. That's my personal testimony as to how I found out about the project. So I'm not going to argue that point too much. If they feel that that's not me hearing from someone about a project, they don't think that's how things work, that's fine. So I'm not going to argue that one. If we could go down to the item number 2,
Can you see that? Yeah, I'm down. It should be appearing there.
I do have notes here, so I might just read from them if that's okay.
That's fine. Please go ahead.
So I am not an expert witness, but I'm capable of reading material such as studies done and drawing conclusions from them. I'm simply restating what these papers have already mentioned. Specifically regarding the Berkeley study, it shows the value decrease in a neighboring state with agricultural land being used for the project. This
Can
is
I
what
just
will be
interrupt for a
happening.
second? Just slow down a little if you're reading off the paper, because we need the
Sorry.
transcriptionist will lose track. Yeah, go ahead.
Do you need me to back up at all? I'm sorry.
No, you're good.
She's good. She got it anyway. Okay. Go ahead.
This is what will be happening with the applicant's project. Taking the information published and applying it to this project is not me making up information. It's using information available to make conclusions of what can and most likely will occur in this area as well.
Keep going. Just let me know.
Number 3, I will be submitting documentation showing my diagnosis and the factors that surround such a diagnosis. I do not have a medical degree, as the applicant mentions, but I am an expert on my own experiences and what typically causes issues. My daily life is a constant battle to ensure I have medication ready to take if a migraine occurs, and doing anything possible to try to prevent an attack. This includes wearing sunglasses during almost every car ride, including on cloudy days and rainy days. I rarely sit in the sun without some sort of shade. Any activity that I go on or do, I need to take preventative measures to ensure that I have the best chance of not getting a migraine and the tools required in case one does happen. This is a constant level of anxiety for me, and to have the applicant try to disregard my issues simply because I do not have a medical degree is a low blow. If I could flip a switch and not have this issue, I would in a heartbeat. The level of planning and care it takes to make it through a normal day now is already high. Any added amount of glare, which the applicant states in their application, will impact my property. And there is a high probability that the factors surrounding my attacks will increase, causing either more attacks or more of my time and energy avoiding even more areas of my life.
Okay.
So number 4, the PSC has already been given information through the Kashkanan docket about how there could be injury and death occurring to migratory birds in a case like this. So I'm, again, not making claims that haven't already been mentioned before.
Okay, but your testimony speaks to this project. It's not doesn't talk about the Kashkanan project.
I understand that, but in that docket, it states that projects such as these, not just theirs specifically. Let me try to find I had it up here. Give me just a second. I'm sorry.
And Your Honor, just some process,
So-
are we going to be able to respond to these? I just want to make sure I understand the process. after
The
this.
individual, yes, I suppose. I think you covered it in your initial topic, but if you want to do an individual response, we can allow that. Yeah.
I'll wait till Ms. Tan's done.
Mhm. Okay. Yeah, go ahead, witness time.
Let's see here. It was stated by one of the, please forgive me, my brain isn't working at 100% today. One of the witnesses for the Kashkanan project that they reference a study that suggests that areas should not be sited in close proximity to open water or agricultural fields.
Okay. Well,
And that
I'm
was
just
a
curious
site,
about about the testimony you've provided. So it's page 5. And I'm just going to use the one from the motion because it's easy to pick out. So it's page 5, 104 through 108. So that testimony doesn't make use of or reference Kashkanan. You're just talking about the current project in the case.
Yes.
Okay, that's what I just wanted to confirm. When you mentioned Kashkanan, it wasn't actually in your testimony that you're.
No.
Okay, all right, thanks. That's fine. Okay, thanks.
And going back to that, I don't think you need an expert opinion to know that when a fence is put up, especially a deer fence, it will impact how animals can move through the project area.
Okay.
I'm not claiming to be an expert at any of this, but I can draw conclusions based on observations in nature.
Okay.
Do I need to wait for a response back, or
No,
how
I
are
would
we
just go
moving
ahead.
forward?
We'll just treat it like you're filing. So we'll get all your responses first. And then if the applicant has a reply to anything in particular, we can take that.
Okay, the next one, what's it, number 5?
Yeah.
According to the applicant's glare study, there will be yellow glare directed at my residence. If this is speculation, then that should be noted, and a new glare study should be completed by an independent third party. The real potential noted comes from the applicant's own documentation. So I don't understand why they're negating the information they're attempting to use to get the project approved. The applicant has stated in previous filings that my property will not have a view of the project due to a natural landscape surrounding my property. However, there are no trees on my property that would impact any view or glare coming from the project.
Okay.
Number 6. I would like to apologize. I did make a mistake in my testimony. I know it said county. That should have said country. Was my intent for it to read videos of several solar projects throughout the country. I'm aware Badger Hollow is not in Columbia County. As a resident of the area, I'm able to use my own ears to hear how noise travels through the area. It does not take a technical degree to hear birds or tractors in the fields and how their noise carries down to my property. As stated, I've lived here for almost 4 years, almost 5, and have been able to witness and take notes of phenomena such as noise travel. Number 7. The applicant is attempting to skirt around the issue by stating they're technically not a utility. However, they're going to be producing energy, something a utility does. They've also stated that they plan on selling the project to a utility company, but should not be held to the same standards as a utility. I would be similar to say that I could build an industrial sized building, but since I will first own it myself, it shouldn't count as an industrial building for zoning ordinances or other regulations. If the intent is for the project to ultimately become a utility, they should be held to the same standards. Number 8. The statement the applicant is referencing is stating what the Wisconsin state statutes is citing. Local governments are not given the final approval, nor any significant approvable capabilities for wholesale merchant plant siting. That currently is held by the PSC, and the reason both the applicant and myself are parties to this docket. If the town of Courtland or town of Springvale had authority to approve this project, we would not be making these motions or going through this legal proceeding at the moment. So the next one, the applicant's referring back to the previous strike on lines 185 through 190. I'd refer back to my response to that submission as well. The next one, number 10. So even though this comment from Columbia County has not been added to the record, it has been approved through the County Board of Supervisors and should be allowed as a statement of what the county is trying to address when it comes to these types of projects and their potential impact on the county as a whole. If desired, I can resubmit the exhibit without reference to the filing through the PSC and only the vote and desire of the Columbia County Board of Supervisors to make the PSC aware of their desire to curb these types of projects. While the statement references a specific project, several of the concerns addressed in the statement are universal throughout the county. 11. The applicant's correct that I do not have any formal education on engineering. However, I'm aware of how gravity works and the properties and movements of water on a slope. Specifically in the fields addressed near my residence, there are drainage ditches that flow down into the wetland, which are visible to the naked eye. 12. While the applicant is correct that I do not have any formal education in real estate appraisal, I am able to read and draw conclusions from documents. 2 of such documents have been presented as exhibits, showing where my conclusions have been drawn from, and what is not listed is the other documents I've read and studied that show similar conclusions. I may not be an expert, but I am able to read and understand documents, research them, and learn from them.
Do you have any separate
So
comment?
I'm sorry, go ahead.
Do you have a separate comment for item 13, or is it similar to the last one?
Item 13 and 14 would be a similar response.
And just for my understanding, are those peer reviewed, or there was one was conducted by the Department of Environmental and Natural Resource?
So those would both be self-authenticating documents. The one through Berkeley is published in a peer-reviewed journal. So these types of studies are and should be submitted as proof of the conclusions listed. The papers discuss all of the conditions used to make the determinations that are stated, and should answer any questions the applicant has in regard to the development of the studies and their conclusions.
So that covers 14 as well. Okay.
Yes. Um, 15. Due to the compensation provided by the applicant to the company and individual submitting the report, it's not unreasonable to conclude that the report would only favor the applicant and not show any disadvantages that an independent third party could possibly conclude from the same data. It's for this reason, during most other types of proceedings, that reports such as these that the applicant has submitted are done by an outside party with no connection or affiliation to the party involved in a dispute. Uh, 16, the portion of the case referenced Just vs. Marionette discusses the rights of a property owner which in this case I am. While in this docket, the applicant is not taking my land, they are impeding on the use of my land with the construction of this project. Um, 17. As a witness to migratory patterns of birds that fly through my property and land in the surrounding areas over the last 4 years of living at my residence, and also understanding the way migratory birds move, I feel that the statement given about such birds come from personal testimony. It does not take an expert to notice patterns of behavior and movement of animals, especially when they are abundant and visible as they are at my residence. As a resident and hunter of the surrounding community for many years, I've been witness to the movements of animals in the area. It does not take an expert to note movement patterns or to witness breeding behavior in rural settings. In fact, on April 4th and 5th, I witnessed several deer moving and grazing through one of the areas the applicant has proposed for arrays across from my residence. While I may not have an education on these matters, I can that I can test the statement that I do not have skill to notice patterns, training to hunt animals, or any experience doing so. In order to be a successful hunter and collect animals in a responsible manner, it's imperative to learn the behaviors of animals, which I have done. 19. Well, the applicant is correct. I do not have a degree that allows me to practice medicine. I object to the implication that I do not have any knowledge on my own medical conditions. I'm the only person who experiences my symptoms and has knowledge of the conditions and complications created by them, making me the only expert there is to testify on my specific medical condition and what can lead to a medical episode.
And that's all I have. Is that the end? I may have, by copying over, did I miss anything?
That's all I had.
Okay, good. Okay, so now we can, so did you have anything else to add in terms of response to the motion, or should I turn it over to the applicant or other parties to comment?
You can turn it over.
Okay, all right. So let's hear from, if the applicant has responses to those direct items, please do so, and then we can give an opportunity for other parties and staff to give their comments as well. So who wants to take that on?
Your Honor, I'll take it on here. And just as an opening statement, and you can tell from the strike throughs that you just went through, Ms. Tan has raised 4 primary issues in this case. The impact of the project on her health, the conflict with land use plans, property values, and then allegations of the impact of the project on wildlife and water resources. And the selective strikes we've done here do not eliminate her ability to argue any of those. And she has testimony in this case, if the court grants our strikes on all of those issues. Again, our narrow concern is her ability primarily to testify about areas that are more properly and foundationally appropriate for an expert witness. I don't want to respond to, I'm not going to respond to each one of the issues, although I do have a few responses. We'll stand on our brief. I believe Ms. Tan on issue 1 has conceded that it's hearsay and should be stricken. On the 2 reports,
Just give me the, do you have the item number, or give me the page numbers just so I can advance the screen?
Let me walk through them a little more orderly.
Yeah.
So number
Okay.
1, she has conceded, I believe. On issue 7, just a factual statement Ms. Tan made in her arguments here today that the project is going to be sold to a utility. That's not accurate. I just want to represent that the record does not reflect that the project is going to be sold to a utility. There's a number of options available. On item 10, the Columbia County Board filing in a different docket. I believe that's rote hearsay, and it's also prejudicial, right? If Columbia County wants to take a position in this case, as it did in the other case, it should feel free to do that. But the implication of that is that they have the same view on this project as they do for the Invenergy project, and that's not in this record, and I don't think should be bootstrapped into this record based upon Ms. Tan's request. On item 11, and just as an example, the text, which is at page 19, lines 403 through 408. I just want to show this as representative of why we struck this testimony and testimony like it. If you look at those lines,
Am I in the right place?
correct. If you look at the statement that she makes on 403 going into 404, indicating ultimately that, quote, grading will have to be done throughout the hillside, end quote. She has no basis for a statement like that, right? She doesn't point to any expertise. She doesn't point to the record. It's simply a raw conclusion in an area of engineering expertise. So As an example of the kind of strikes we've suggested here, we're not trying to strike her ability to claim that the project's going to be built on slopes of greater than 10 degrees. She's actually wrong about that, and we'll deal with that in rebuttal. But we're letting her say that here. It's the expert testimony on this topic that we think should be stricken. As to item 13, the Rhode Island report is not peer reviewed. And I believe that's the
I
reason
didn't say that.
Okay, hang on. One person at a time. So the Rhode Island, that's the Natural Resources University report. Yeah, I see that. Rhode Island.
Correct.
Not peer reviewed. Okay. Well, that's a good clarification. I was confused about that. So go ahead.
And I would note that this court struck that document in a different matter for that reason, is my understanding. On item 15, I guess Ms. Toms claims that there's bias in the reports that are done. I would just note for the record, the report she's speaking about, Dr. Loomis's report and his testimony is a third party. And she certainly has the ability to cross-examine him at the hearing. But the inference is that all of the third party work here is biased by definition because it was ultimately requested by the applicant. And I think that's an unfair bias, and that's why we moved to strike it. I'll stop at that point, Your Honor. I know you also had questions on other pieces of case law. We're happy to respond to those as well. At the end of the day, I want to say this up front. And I've been involved in a number of cases with pro se witnesses. Ms. Tan has been very fair in this case. She's been polite. We are not striking her testimony out of animus or out of a belief that she's taking, in general, unfair attacks on the applicant. We don't believe in general she has the foundation to make this testimony. We believe she can make all the points that she has done here, as she has done, or as we've represented in the stricken testimony, and still get her points across without going over the line on what is properly expert witness testimony.
Okay, thanks. Comments from other parties? General, specific, or otherwise? No? How about commission staff? Anything?
No comments, Your Honor. I would just note that, the commission's made clear in their prior order on things that they can assess probative value of things to an extent. But I'd also point out that those participating as parties need to take the responsibilities for participating as parties as well. And I think that that's in play here as well. And I would just reiterate that I think information from outside dockets stay in those dockets outside of being offered in this one. And that's it, Your Honor. Thank you.
Okay, great. Yes, you succinctly gave me exactly why I have wrinkles on my forehead because there's definitely two valid points to be made in this case as usual. So yeah, we need to fulfill that duty to decide. Let's see if there's nothing else on the motion per se. I can move on to my conclusions. I will go through some general background on this, make some general rulings, and then apply those to the individual items that were subject to the motion. So if I can find the document somewhere on my computer here in front of me, we'll get to that. Right underneath here. Okay. You don't need to read along. So I'll just leave. I'll leave the table up here because we'll go through individually each item. But let me just discuss my ruling here. So I want to thank everyone for participating in this way, and I think it does offer us an opportunity to efficiently address the matter and provide an opportunity for us to move forward without delay. So although this is taking some time right now, I think it's a good investment. So let me say, in terms of the motion, I can read off some of what I had concluded prior to the hearing, and I think has not changed significantly from hearing from the parties today. So the Ursa Solar motion invokes the standards articulated in the order on motions to strike offered evidence in docket 9805 CE 100 and applies them to the town direct. The Onion River order addressed the offer of evidence by a party landowner lay witness, portions of which were inarguably an incoherent, hyperbolic diatribe of faulty accusations that Onion River Solar could not reasonably have been expected to comprehend, let alone coherently rebut. Significantly distinguishable from the evidence at issue in Onion River is the town direct. The town direct is a coherent, measured, logically organized presentation that contains allegations reasonably related to the evidence offered by Ursa Solar, and to the CPCN standards. Therefore, I refuse to reflexively apply the results of the Ursa Solar order here. The Ursa Solar motion, by applying the standards of the Onion River order to the town direct, invites the commission to negate a landowner's right to participate as a party by asking it to prevent a lay witness from testifying to facts it could otherwise offer in a public comment. As a general matter, this result should be avoided whenever possible. So in general, where the town direct offers a relevant and logical presentation of facts to which Ursa Solar may reasonably rebut, I will receive the town direct and allow Ursa Solar to meet its burden of proof to support its application on the merits. As a primary ground to strike portions of the town direct, Ursa Solar asserts that both the law requires such testimony to be offered by a certified expert and witness town lacks such required certifications. Ursa Solar argues that Walmart stores, I believe we've cited that already, provides the standard to strike such testimony on this ground. However, this case dealt not with what evidence the commission may see, but what evidence meets the substantial evidence test upon which the commission may base its decision. At least in this case before us, the commission in its order on interlocutory review has indicated that it wants the record open to receive perspectives of interveners that, and I quote, may assist the commission in its review. That's page 5 of the order. The study at issue in the order on interlocutory review and the town direct both serve this purpose. Like the study, the commission will use the town direct as part of the sifting and winnowing of the entirety of evidence to be received in this proceeding. To the extent the applicant wishes to challenge witness town's competency on the matters asserted in the town direct and refute the contents of that evidence, it has ample time and resources to do so. Ursa Solar also cites Wisconsin statutes 907.01 and 907.02 to propose that, I believe this is a quote from its motion, Wisconsin law prohibits opinion testimony by lay witnesses based on scientific, technical, or other specialized knowledge, and requires that an expert witness be qualified as an expert by knowledge, skill, experience, training, or education. While administrative procedure contemplates the limited use of civil procedure statutes that do not conflict with this chapter, and we cite Wagner versus State Medical Examining Board for that premise, there are many instances where civil procedure under 907.1 allows a lay witness based on that person's rationally based perception and I don't think I got this sentence right. Well, basically, the statute requires or allows a layperson to use rationally based perceptions to help a determination, a clear understanding of the witness's testimony or determination of a fact and issue. So that's what the statute allows a layperson to testify to. And also the statute, the annotated statutes also provides a citation I think is useful in this context. It's using lay opinion evidence at trial, Cody at Wistlaw, May 2009, that discusses the application of lay witness testimony. And because of that, I refuse to determine as a matter of law that expertise is required to present evidence of reasonable probative value. I'll leave it up to the commission to decide, based on the totality of the evidence, to what extent expertise will assist it in making its determinations. Furthermore, should expertise be required to testify on matters raised in the TON direct, remains unresolved as to whether witness TON demonstrates the required expertise. I say that regardless of the fact that the witness has admitted technically she's not an expert in these fields at issue, but I think she begs the question by explaining her experience involved in that. And I think and we'll get to this, but so the difference really is what is the nature of expertise and what's required in order to make that determination and use that testimony in this context. So to continue, while Ursa Solar claims an expert must hold a certification in order to testify in the fields in contention, for example, engineering and medicine, Casimir versus Herman, and that's CASIMERE versus Herman, 28 Wis 2nd 437, and cases that follow instruct that, nevertheless, qualification of an expert witness has historically not been a matter of licensure, but a matter of experience. During periods of epidemic, when laypersons were extensively exposed to disease, they were competent to testify in regard to particular diseases with which they were familiar. In Wisconsin, we have held, in view of this knowledge of the condition of dead bodies, that a non-medical coroner could give his opinion of the time of death. It's citing cases to that effect. This court has allowed the testimony of lay witnesses that an applicant of a life insurance policy was apparently in good health, citing another case. Therefore, I refuse to determine as a matter of law that witness TON's lack of licensure disqualifies the witness as an expert. I'll leave it up to the commission to decide, based on the totality of the evidence presented, to what extent it considers witness TON an expert. So with that, you see that mostly in favor of or mostly denying the motion on those grounds. As you can probably perceive. And I can go through the particulars so that we can get any refilings dealt with here. So I'm just going to show the particular portions of the table here with the particulars. So I'm hearing there's somewhat of a consensus that that item 1, objection 1, involves hearsay. I didn't read it that way, even though everyone else seems to think so. I think witness TON is just telling us what she heard community members say, which Ursa Solar can seek clarification on if it wishes to, in terms of the timing of what the witness heard and when, on cross. I think I'll just leave that in because I don't think there's really any harm to it. In terms of objection 2, deals with property value. And actually there's a few of these. I think in this particular section of testimony, we're dealing with opening remarks. So I'm denying striking that. I think an opening remark need not include all the facts that a witness plans to assert and support. And for the commission to agree with that sort of conclusory statement, it would need to find substantial evidence in support of it. And that would require the commission to evaluate witness TON's full presentation on the matter and weigh all the evidence presented on the matter in light of the offered evidence, in light of the offered witnesses' credibility and their various levels of expertise. So this will be a theme here. Again, item 3, it's the same in terms of introductory remarks. I think in response to this particular item, witness Tan just responded saying that she will be filing documentation in terms of medical condition. So in terms of process, technically that should have come in on direct. And I know that there's been some discovery involved in that on that issue. So I think parties may have that documentation. Maybe that's why the objection was made. But in terms of getting in the record, it should have been in on direct. Although what I'll do is, because we have a pro se party involved, I'll allow that to come in technically late. But I'm not sure. I think if you would just file it as soon as possible. Well, I mean, I'm assuming parties have this documentation. I haven't looked at the responses to discovery. And someone comment?
Your Honor, Ms. Tan has not yet responded.
I
Okay.
have not responded yet. I'm still working on my response, but I do
So,
have that documentation
if you could,
available.
okay, so if you could provide that documentation now to the parties as a discovery response, at least get that filed and served. And then I think it's at that point, it would be okay to just wait for rebuttal to include it on rebuttal. Again, I'm just making an exception because you're not represented by an attorney. I think we would hold that. I think we would have expected to see that on direct, but I think in terms of the technicalities of laying foundation, et cetera, I don't know if I can expect pro se parties to get that without any other instruction. So
I
again,
will submit that. Thank you.
so yeah, as soon as you can, just file that and serve that documentation. 4 again is a introductory statement, so same, denied on the same reason as objection 2. Number 5 deals with our well, I think we've gone through it. I'll just read the decision. That's denied. Testimony is directly responsive to evidence Ursa Sola offered in its offered evidence and in discovery, or lack thereof, which is the point the witness is making. Witness Tan applies that evidence to the witness's direct and intimate knowledge of the property. Therefore, the Tan testimony is not merely speculative. Burden of proof on the matter is on Ursa Solar. Ursa Solar may rebut the assertions of witness Tan with the level of expertise it believes is required and will convince the commission of its position on the matter. For the commission to agree with witness Tan's presentation on the matter, it will need to weigh all the evidence presented on the matter in light of the offering witnesses' credibility and their various levels of expertise. Ursa Solar may present testimony with respect to the extent a prediction of glare requires expert analysis. Ursa Solar may also cross witness Tan to establish the witness's level of expertise on the matter or lack thereof. Commission is capable of using that record to determine the extent to which it may rely on the Tan evidence. Yeah, that's about glare, right? So item 6 deals with noise. Again, I'm going to deny it on the same ground as objection 5. I'm particularly sensitive to, you can't really listen to a video of noise and be able to understand how that sounds in the real world. I understand, witness Hankard in other cases would be, I can hear him telling us how it's really not an equivalent thing, but I think the same ruling applies, the same reasoning applies. The commission can weigh the evidence based on the various levels of witnesses' expertise. I think it's valuable to at least get the witness Tan's perceptions on the record. In terms of the zoning ordinance, I saw this very differently than I suppose either one of the parties. But I'm denying that part of the motion. Witness Tan appears to me to offer this testimony, or I read it as saying It's not to establish the legal requirements applicable to the project, but to demonstrate local attitudes as expressed through the zoning ordinance. Such presentation does not require legal expertise to assert. And again, for the commission to agree with witness Tan's presentation on the matter, it will need to weigh all the evidence presented on the matter in light of the offering witnesses' credibility and their various levels of expertise. Ursa Solar may rebut the assertions of witness Tan with the level of expertise it believes is required and will convince the commission of its position on the matter. It may also cross witness Tan to establish the witness's level of expertise on the matter or lack thereof, and the commission is capable of using that record to determine the extent to which it may rely on the Tan evidence. Item 8 deals with the differing roles of local government. I think you're trying to talk about the process of setting up comprehensive plans and how that may be in conflict with land use proposed. But again, just denying it on the same reason as just stated before, objection 7. Objection 9, this repetition, I'm denying that. I don't think I really need to get into why. Objection 10, it's denied. This is a little trickier. I do agree. I think even Attorney Peters recognized we don't usually bring in documents from other dockets into this one. I understand. I think the applicant's position on this. What I would say is I will deny it. I would also offer as a sort of a concession, I suppose, that if the county does file a resolution that expresses a concern or whatever it wants to express on the current project, we could we'll accept that, of course, as a public comment if it's filed timely, but also I guess I considered updating the direct to just simply trade out the High Noon Solar resolution for any resolution we get on this project. But so that was one option. But I think as it sits now, I'm going to deny striking the inclusion of that resolution. Let me just read what I have here for the record. So the offered comment is an official resolution of Columbia County. It was filed in docket 9814 CE 100 by the Columbia County Clerk. It was not received into evidence in High Noon Solar because it was filed after the public comment deadline. However, like the Columbia County Comprehensive Plan, the resolution is an expression of the locality's position with respect to orderly land use and development in the area of its jurisdiction. When such information is properly and timely filed, a party should not deny the commission the opportunity to consider it along with other evidence. And so an official document of locality or, a court case, FCC, FERC, we accept those documents on the record as a matter of practice, and if it furthers the record, if it assists the commission in making its decision and it's relevant. I think in this case, although it's filed in another case and it deals with a different project, it does evince the county's attitude generally, as does the comprehensive plan. And in that sense, it's relevant, has probative value. I think the commission can also weigh the fact that it does deal in particular with the High Noon Solar project, not this project. It can use that in its consideration of the weight of that evidence. So that's fair.
Your Honor, may I just be briefly heard for the record on this?
Yeah, go ahead.
So the court's allowance of this Columbia County document into this record presents the ironic situation, as you've noted, where this document is not in high noon, where they specifically wanted to have a comment in. They've not made the comment in this docket. We don't know what their view is on the record, yet the court is allowing it in here. I disagree with the basis of it. I think it's pure hearsay, and as I noted in my earlier comments, is highly prejudicial. We don't know how the county feels about this, and the inference here is that the county feels the same way about this proceeding as they do about high noon. I object.
Okay, noted. And so let me just clarify or just elaborate that although the comment was improperly filed in high noon, it was properly filed here in terms of timing. So it does allow the opportunity for the parties to respond to it and present its positions on its applicability and weight. So in that sense, I don't believe it's prejudicial. Okay, so 11, the same reason as objection 5, denying this, since it talks about grading and having and needing, I suppose it's engineering expertise. So objection 5 would apply. My rationale for the objection 5 would apply there. Same thing with property values. I think commission can hear that evidence and weigh it. The in terms of I'm sorry, that was item 11 and 12. So item 13, this deals with the Rhode Island study. I was going to deny that basically without more explanation than the similar to objection 5, but I did want to note that in terms of the peer review issue, I do hold that as sort of a touchstone in terms of when we have competing studies that parties are offering and they're in contention, that peer review does provide some sense of validity and is a good way to gauge whether studies are comparable in terms of their competence. But I do note that to my knowledge, the study that commission did allow in its order on interlocutory review, the solar versus ethanol study was not peer reviewed. And if I'm wrong, correct me now. So in that sense, I think at least in this case, what's been telegraphed to me from the commission is to let in these studies and allow them to evaluate their validity. And I will continue with that standard in this case and allow the study in, although this one has not been peer reviewed. Item 14, again, same objection as same reasoning as objection 5, it's denied. Item 15. Yes, this is where I'm denying in part and granting in part. It's a statement about the well, first of all, let's see, denied in part. I think the item that I would keep in testimony is the TON page 20, lines 436 through 437, that states, with no data to back up such claims. I think this is a fair assessment of the record, at least as it sits today, because I don't see a study or analysis on property value. And I think that the witness Loomis referenced one, but did not provide it as an exhibit. And I think that's something I'll give the parties an opportunity to correct, based on this kind of letting things in standard. But I think it is a valid assessment when reading that direct. I would grant striking in part the TON page 20 lines 437 through 438 that's quoted any testimony given to this effect thus far as financed by the applicant, and then to the end of that sentence. I think this statement violates due process because it lacks the specificity to allow for fair rebuttal. Item 16 is denied. This deals with this Just v. Marionette. Granted, that case can be distinguished. I think this statement reasonably invokes, however, although it can be distinguished, I think this statement reasonably invokes the CPCN standard of undue adverse impact on the aesthetics of land and water and recreational use. Read in that light, the testimony is relevant and possesses reasonable probative value. I've always read that quote in that statute seems to be very similar to Just, and I maybe the reason why it's in there at all, why the statute references it, but I think it as far as it being related to the CPCN standards, I think that testimony is relevant. 17 is denied in part for the reason stated on objection 5. And this deals with referencing phase 2 of the project in terms of migratory birds. So I was granting that motion in part in terms of relevance. I would strike the TON page 22 lines 467 through 468. That states not only for this project, but for a potential phase 2 that the applicant has indicated in letters to residents, and the possibility of a phase 2 being developed and any potential impacts of a phase 2 are not an issue in this proceeding. 18 denied, same reason as objection 5, and that deals with claims for hunting, travel, breeding grounds. And again, the commission can weigh that testimony. 19 is denied. This goes in terms of medical issues, and I think we addressed that. I think this just really reiterates my prior statements in general that commission can weigh that. What witness TON will present, and how the witness applies that to her, applies facts of the project to her condition, is something the commission can weigh in terms of whether it needs expertise, how much expertise it needs, and whether a witness TON meets that standard. And again, Ursa Solar can rebut and can question witness TON on her expertise, provide information to the commission whether and to what degree expertise is required to make the conclusion she's drawing. So that's all we have for the motion.
Your Honor, can we go back to 17 just to make sure we got the strike correctly?
Oh yeah,
so we understand it.
What
was the actual strike you were granting?
So let's see. Do I have the? I don't. Well, I do have it here. Let's just bring it up here. Page 22. So it would be the reference to phase 2. So not only for this project, but for a potential phase 2 that the applicant has indicated in letters to residents. That would be what's stricken. So
okay.
The rest of that would be in.
So it would read, because of the proximity to Paradise Marsh,
yes.
There is a real risk of harm to migrating birds.
Yeah.
That's how it would read.
That's how it would read.
Thank you.
Yeah.
Thank you.
Yeah. Okay, any other questions about that? So the process would be, we'd need to have a refiling of the TON direct. That would have to come from witness TON. And the stricken portions would just be covered in black like redacted. So you could just leave the it's probably not a good example to look at, but you'd leave the testimony in, except for example, this section, the not only this project, but for a potential, that would just be blacked out. So that the commission couldn't see it at all, but you can leave the same page pagination and same lines in the testimony. And you're muted, Lauren. Yeah.
So I need to refile the document with those redactions.
That's right. Yeah.
Will I be able to get a copy of the what you just showed us? So I can take from your notes the references and make sure I have the right places corrected.
Right. So that'll be in the transcript. When you get a copy of the transcript, it'll be in there just like we read it.
Okay.
Okay. So you can wait. I can give you some time to file this. I think everyone understands where we're headed. So the timing of that filing isn't too critical. We know what the state of the testimony is at this point. We can work with it through there. So I can give you like a week or so, or if you want to file it on the deadline of rebuttal, except I'm not sure what that when that date is right now. You can, I think there's to 21st, I think that is. So there's some time to file that. So let me just say, file it at the same time as rebuttal.
Okay, thank you.
Okay. So I did have some other issues. Did we want to take a break for a few minutes or keep plugging on here? Because there's some other issues to deal with.
I think keep going, Your Honor, if others are game.
All right. Okay, done with that. So let's bring up, probably the best thing to bring up is the comments here so I think the next thing I want to discuss is to review the comments I've made so far in the this kind of draft offered evidence list. Let's get these things out of the way before so we don't have to deal with them later, and it'll give us some time to correct this now. Okay. So yeah, so we can deal with sort of the more substantial changes, but let me just get any questions about the regular style formatting changes. One thing I wanted to add was witness Ton, the pagination actually should change on your refiling. You should have a number 1 as your line number on every page, at the top of every page, instead of going through as a sequential numbering throughout the whole document. So every page should start with line 1. There's a setting in Word. If you're using Word, there's a setting for that. It's got to kind of, if you Google it, it should come up. You have to kind of dig around. Do you understand what I'm referring to?
So like in my direct testimony, the first line says 1.
Right.
What am I doing wrong there?
So here's Clean Wisconsin's direct. So every page starts with 1 and goes to the last number, and then it restarts with 1.
Oh.
And yours just goes sequentially all the way through. So we usually cite things. Well, we don't usually cite the line number, but if we're referring to the line number, it would be page so-and-so, line 1. And then the next page could also be the next page, line 1.
Okay.
Yeah, that's just we just want to be consistent with that. Not that one's really wrong or right, but that's how we set the standard. So that was one thing I thought may be confusing. Any other confusing formatting questions here?
Your Honor, I had a question about the live link issue in this case.
Yes. Okay.
Thank you. So we've in all of our exhibits here, we've bracketed the lead domain like we've done in the past, and which has worked in the past. And I do recognize when I opened up these on Adobe, it was putting them back in. So I don't know if that's an update to the software or what, but I was wondering if you have a preference for how we should go about disabling those links now that the bracket isn't working.
Okay, and okay, so you've tried to do, I didn't know. Okay, so it just put it back in. So what I've noticed, and this, I guess I didn't do this too long ago. Oh, so this .gov,
Right.
does it actually get you to?
I think it depends on the software that you're looking
Yeah.
at it with. When I opened it with Adobe, it was taking me to the sites in
Okay.
some instances. So I mean,
Yeah,
I don't
so
know. You wanna-
what I noticed, actually, we can go off the record for this, give you a break. This is just formatting stuff. So what I noticed, that helps if you trade the dot for an asterisk,
Okay.
that might work. It's worked for me, but then again, sometimes these things work, sometimes they don't. Yeah, I think we may be seeing the elimination of any use of links at all in testimony, because this has just been a hit or miss. And you just have to put in the citation that people could, if they wanted to, find through search. So that's not applying in this case, hasn't come out yet, but we've just been everyone's been frustrated by that link situation. But for some reason, it's not working on me. Usually I'm able to get them to work if they do work, but you said that they did work for you, so.
Yeah, at least in some of the cases, yeah, like there, when you scrolled over, it gave you the.
Right, but if it doesn't actually open anything, that's okay. So, there may have been or two. It must have opened it. It must have opened at some point because I asked you to change it. So that's weird. Okay, well, I don't see it working at this point. I don't know if you, well. Let's see, okay. I don't know, I'm not getting them to work now. Maybe, oh, there we go. Okay. Maybe, oh, it might just be slow. Okay, so there are some that are working. Okay. Yeah, I guess just give it your best try. Give it a college try. Just want to make sure we're catching those things when we can. Yeah, that's bracketed, but it still works. I see that now. Yeah. Yeah, I would say do a test, see if asterisks work. If they do, then refile with the asterisk. If it doesn't work, I mean, we can't let that stop us, I guess.
Your Honor, this is Eric Callisto. Can I ask a question on process here?
Yeah, okay.
Traditionally, we've had this exercise at the technical hearing, and you've asked for these corrections to be filed in whatever the traditional timeline is for that.
Mm-hmm.
Is that going to be the request here still?
Yeah.
Or are you asking for these corrections to be made in advance?
No, as long as they get in before, well, let's see. There's going to be a few. I think the formatting should be after the hearing. Those corrections can be made after the hearing, because especially if we have something else that needs to be corrected during the course of the hearing, this way you don't have to refile. So there are a number of more substantive changes here in the comments that'll be different, but and they just may cause you to need to file earlier. But I think, yeah, if it's simply formatting corrections, then leave it till after the hearing.
Thank you.
So again, any other formatting corrections? Okay. All right, so in terms of more substantive comments, let's get on the record for that. That's probably not. Okay, so I do want to address, just for our understanding, in terms of Appendix L in the application, I was asking Ursa Solar to add any sample joint development agreements that Ursa Solar has offered to begin negotiations with the localities. Is that something they can do at this point, or something that is available?
Your Honor, the JDA negotiations and the good neighbor agreement negotiations are just that at this point. They're in negotiation. So I'm not comfortable providing those draft documents to the record. I think it would impact the ability of the applicant to fairly resolve these, as you can imagine, quite contentious negotiations, at least with the two towns in the county. The AFR at section 6.1.1 asks for a summary of what's in the JDA, and we provided that to commission staff in our response to PSCW AC 4.3. Staff in that same discovery request asked for executed JDAs once they are obtained, and we will certainly do that. But at this point, we don't have an executed JDA, and I do not want to provide it a draft at this point to the record.
Okay. That's the first time that's been objected to. With other projects, we've been able to do that. So, and I'm just trying to be consistent with past projects. But I'm recognizing your concern. I think we can stick to the filing requirements and the data request as providing the information the commission will need. The filing requirements may change in the future, but at this point it remains the way it is. So I won't push the envelope on that based on your concerns. So I did have a concern or a question, and okay, I'm going through the exhibit list, not the testimony. So I think that the issue is the same though. So I think it looked like witness Loomis had referred to a University of Texas Austin study with respect to property values, but as far as I know, that's not in the record. I don't think I need to help and correct that problem, but I think I will, because in light of the rulings today and the kind of the preference here that we've seen to be more inclusive. And so I wanted to provide that opportunity for the applicant to benefit from that policy as well. So I would allow the filing of that study. That could be done as Loomis 2 and just filed as soon as possible. Is that something the applicant, should I expect that from the applicant?
We can do that, Your Honor. I would ask, because we're on the verge. Well, if the court wants it right away, we can file it right away. I was going to say we can put it in a rebuttal as well, but whatever the court prefers.
Yeah, if it just filed it as an exhibit, that shouldn't really take too much effort. And then we just need to refile the testimony referencing the exhibit. That can be done later after the hearing. But I think we want to get that to parties as soon as possible. So yeah, if we could file that right away.
Got it.
Okay, so now let's see, this is testimony. So we have issue on the Mathewson, Clean Wisconsin testimony for First of all, I wanted to clarify that I believe what witness Mathewson is referring to on its direct pages 2 and 3 are comments submitted for the environmental assessment process. And those comments won't be received for the record. They're not meant to be in lieu of public comment testimony. They are simply to assist staff in creating the environmental assessment. So it's not appropriate to file, just reference those. And then if you wanted to reference public comments, you do so by using the nomenclature of the public comment exhibit, which, you know, has a certain wording, and then adding the public comment name at the end of that. So for example, and the reason for that is the public comment exhibit includes the comments that I am accepting for the record and none other. So I will, you can, however, put environmental review comments into the record if you offer them as exhibits, and that's been done many times. So just so that's indicating that if we have a Mathewson 6, submit those comments as an exhibit, and then change the testimony to reference to that, and then we're good with that that reference. It's interesting though, just to note that all those issues with ethanol were not in the record before. So, you know, Clean Wisconsin wants to raise that issue, Commission wants to hear it, but in terms of characterizing as being a response to something in the record right now, that's not really the case. So the other issue, so is that clear with Clean?
Yeah, thank you, Your Honor.
Okay, so we also have the testimony that was introduced by Mathewson on page 11, lines 17 through 21, that introduces and offers for the record the Mathewson testimony in was it Koshkanon?
Yes, Your Honor.
Yeah, and that's Mathewson Exhibit 5 in this case. So, you know, in light of all of what we said about being inclusive, I do feel like this particular way this has been introduced and in the manner it's being presented is prejudicial, because it's saying that look to testimony in another case on another project to get particular conclusions of Clean Wisconsin that are very specific to the area of Koshkanon, and it deals with Dane County particulars. And it's really the testimony I thought would be very useful and should be filed in this case, but for this project in this project area. And I don't know if Clean I don't think Clean is asking the commission to use that particular facts in this case, but we don't really know what is relevant here. What would Clean present in this case had it have done its testimony in the same way it did it in Koshkanon? We'd know exactly what it means the commission to see in terms of relevance and probative value if it had done the same analysis in Langdon Mills as it did in Koshkanon, but it didn't. So to have the part, I don't know if it's, I don't think we can really ask the commission to read that testimony as an exhibit and try to parse out what's relevant and what's not, what's applicable and what's not, what has probative value and what doesn't. And I don't think it's fair to make parties do that on rebuttal, to have to rebut whatever it thinks Clean is presenting as relevant and with probative value. So that's my initial take on that. And I believe for that reason, it shouldn't be received on the record. But I'm willing to hear from parties on that if there's responses from the parties.
Yes, Your Honor. Thank you. We appreciate the opportunity to be heard on this issue. So Your Honor raises two issues with the testimony. The first that you just mentioned is that it lacks probative value because it forces the commission and other parties to determine the relevance of each fact asserted in the testimony and apply those facts to the instant case. But we disagree because The testimony itself only asserts that the types of environmental benefits described in the exhibit are applicable to this project as well. Because the exhibit is only offered to support that assertion that the types, not the specific benefits calculated in the exhibit, it does not force the commission or parties to make determinations about the relevance of each fact in the exhibit testimony. In the exhibit, our witness summarizes a study he conducted and presents data about nutrient reduction estimates for the specific project in that case. But the exhibit here is offered again to support the claim that the types of benefits are applicable. And we think this is like many scientific studies and other publications that are offered as supporting exhibits in commission proceedings. The specific data included in them may not be directly relevant to this proceeding, but they support assertions in the testimony. And again, we're just saying that the types of environmental benefits are the same. I have examples of various studies that have been admitted, including ones, I don't feel like I need to explain them here, but the point being that, you know, a study about impacts of utility scale solar in Western states was admitted in docket 9804 C100. It's the same idea that you can use a study from a different place to draw conclusions that you're asserting here. And as far as the due process issue, the second issue that Your Honor raises, again, we're only offering that testimony to support the assertion that the types of environmental benefits would be the same. That's because the projects are similar in that they're both solar PV projects. They're both similar that they both take place on the same type of land use, that's row crop agriculture. And there's no due process concern because the exhibit and testimony is prepared by the same witness who will be available for cross in this proceeding if the commissioner or party wants to challenge any of the assertions made. And any questions of relevance of specific benefits can be examined at that time. So we respectfully ask Your Honor to allow the testimony and exhibit to be admitted.
Okay. Any other comments from party staff?
Your Honor, this is Eric Callisto for the applicant. We support Clean Wisconsin for the reasons that counsel has just stated. And I would note as well as we look back to what the court has allowed in so far, including the comments filed by Columbia County on a different docket, this seems to be, from a relevance perspective, I won't fight that argument, but to the point that we have the witness testifying on the stand who can be cross-examined on this topic, I think it's equal or of more probative value than what we've seen from the Columbia County board resolution, which is now in this docket as well.
Mm-hmm. Anyone else? Okay, well, I think we may have a compromise solution here. I don't want to limit testimony. I think Mathewson makes the statements that what the general benefits are in the direct that's been filed in this case. I don't really know how much more needs to be said and how much benefit really is given by offering the same direct in Koshkonong as an exhibit in this case, but to give you the benefit of our new permissive process here and to eliminate any confusion, I think, between what is being offered for this record and what may be extraneous to this record by reference to Koshkonong. And in particular, I guess I'm concerned as whether the conclusions drawn in the Koshkonong evidence is based on the data and analysis presented in that evidence. So in a way, they do in the fact that they're presented together Mathewson is drawing conclusions based on the analysis he's presenting begs the question of, well, how much is that particular conclusion in the Koshkonong evidence tied to the analysis that we're saying is not applicable in this case? But I think the best way to balance all of this is to have you refile the Mathewson testimony. There being no surprise to anyone because we've already seen the Mathewson Koshkanon testimony as the exhibit, but I'll allow you to modify the current version of the Mathewson testimony in this case to add to it whatever relevant statements that you believe the commission should see from the Mathewson Koshkanon testimony and put it into the Ursa Solar testimony. So just, I mean, I guess I was confused why he just didn't testify and say what he wanted to say on direct fully and completely. I think that's what we want to see. And the fact that was said before in Koshkanon, I don't know if that's relevant or not, if that adds something. I mean, you can say, as I've also said in Koshkanon, if you want, but I think you want to present direct on direct. You shouldn't need to rely on exhibits from the witness who's actually giving testimony in this case to make the same testimony here. So I'll give you that opportunity just to reformulate your direct to include statements in the Koshkanon direct that you want to include in this case, and then eliminate exhibit 5. And like I said, there'd be no surprise, I think, because we've seen the Koshkanon direct, but let's put it all in the witness's direct statements. I don't know how long you might take to do that. It would be useful to get that in as soon as possible, just so we have page numbers and formatting and we know exactly what we're dealing with for rebuttal. So how long do you think you might need for that?
Can I, a clarifying question, Your Honor?
Mm-hmm.
So the difference between what we're doing here and what we did in Koshkanon was Dr. Mathewson conducted a study in Koshkanon and analyzed fully, the impacts. We're not trying to go into the same level of detail here just because of the amount of time and capacity that required in that case. We're hoping to convey the idea that the similar benefits are going to be there. My clarifying question is, would we be able to include additional exhibits that support further assertions about the benefits, kind of the underlying things behind the Koshkanon study in that case? Because we won't be able to run the same calculations, but we could use the underlying data to support assertions.
Anyone want to speak to that? Okay, yeah, I think I'll allow that and let's just get it in. And but I think we want to just have one set of direct testimony that's filed in this case that parties can then rebut rather than having an exhibit of testimony in the form of an exhibit. Yeah, to the extent you want to support the Koshkanon conclusions, as you claim relate to this case, do so in exhibits. That's fine. And like I said, the commission can sift and winnow this, leave it up to them to decide the relevance and decide at least the probative value. Well, I guess the relevance and the probative value, why not? Of all of this. So yeah, just present it as expert report and have your witness put in all the analysis, all the descriptive claims the witness wants to make in the direct.
Okay, and I think as far as timing, I think would 1:30 on Monday be okay? With rebuttal due on Friday of next week?
Yeah, I think that's probably okay. At least we have the information currently. Well, you don't have those exhibits filed yet. Can you file the exhibits sooner and then get the reformatted direct in on Monday?
Yeah, Friday.
Yeah, that's fine. Yeah, okay. Right. So Friday by 1:30 have the additional exhibits. Monday by 1:30 have the new direct.
Okay, thank you, Your Honor.
And if people are running out of time to rebut, we can work on extending that the deadline for that. Just let me know, or I guess let our attorneys, commission attorneys know, and then I can take it from there. Okay, so we have that. I think. So I think there are some comments that are those kind of clarifying questions. We'll wait for the hearing, but I figured why not give you guys notice of it now. So that's mostly the renew questions. Yeah, we do have, I have a concern, I guess, in terms of renew page 14 through 15, and it may just be a wording issue, but I think I understand the concept witness Vickerman is trying to communicate, but I think making reference to the flow of energy through particular lines may require a show of expertise. And I don't know if, I think maybe that's possible to show that, but I think we may just want to see some more detail on that. We can do that at the hearing. Or the witness may want to draft that testimony to be similar to, I think in past cases, it was just a little more generically worded. So that may be okay. So just to flag that for you, do you see what I'm talking about, witness Vickerman?
Yes. I guess what I would say to that is I have provided pretty much that statement in previous testimony. I just did not have a citation. So if you want me to remove the citation, I can do that. But my expertise, I think, comes from experience with Public Service Commission proceedings that go all the way back to Advanced Plan 6 and understanding how to read a map.
Yeah, I'm aware of that experience. I guess I just, in terms of, I think and like I said, I've seen you make this style of statement before, but I think it's just a little more particular in terms of flowing through a particular line. That may not be so obvious from a map, but I'll leave it up to you at this point. I think we at least want to just flag that, which we've just done. So that was kind of my concern, and I wanted people to be aware of it. If you want to address it, we can do that at the hearing, or if you wish to modify this testimony so it's similar to sort of more generic statements in other cases, then that's fine too. So
okay. I do have a question though on the clarifying material you're seeking. Would it be okay simply to modify Exhibit 2 to include columns indicating which projects are fixed mount versus which projects are single axis tracking?
Let me check. Let me just refresh my memory here.
That's how I would approach numbers 1 and 2 there. I would approach 3 differently, and we can get into that in a minute.
Yeah. Okay. Yeah. I think when it was so that gives us the data, and I guess what I would wonder still is.
I think when you see, for example, how little capacity is actually sitting on fixed mount systems, it's a de minimis amount.
Okay.
As for bifacial, I have to do a little research, and there's a potential problem here in that what was presented in the application may actually not reflect the construction realities in some of these projects that are under construction due to supply chain disruptions and other difficulties in sourcing key components.
Okay, well, we don't need to get into the weeds. Actually, let's, well.
But I do want to address
Okay.
number 3 here.
So let's just make sure we're on the right page here. So we're talking about your page 8 of your direct. Just want to make sure the
Yes.
record has that in there. So for comment 1, I'm looking at the projects you listed for as items 1 through 29 on your second exhibit. And I think if you itemize which ones are bifacial panels, that'll give us the differential.
Yeah, I can do
trying to
that.
think what I meant by quantify the impact. I think because you do talk about at the end what the total capacity is, I think. So I think it's just adding it up is the idea. It was just, if you just mimic, if you just include in your testimony so you're hopefully not wanting to refile it. So I guess, yeah, I think there'd be the quantifying the impact would just tell us what that difference would be between bifacial and, because it's single pane panels. So there, you may need another number in your testimony. That's what I'm saying. And so for item 2, it's the same exhibit 2, projects 30 through 58. So I'm looking for the quantifying single use tracking versus fixed mounted. And I think it's so indicating which ones have which type, but then the capacity estimate, you'd want to have a differential in there. So number 3, compare capacity factor used in Vickerman 2.
I can't answer that question.
I'm sorry, go ahead.
I can't answer that question. What accounts for the difference? All I did was, I noticed the number in the applicant's in the application, but I don't know what is different about this particular project to account for that.
Okay, so we'll wait for the hearing then, just to have you clarify that, just so we know you're not considering. Yeah, that's fine. But we'll just, your answer is fine. I just want to know that on the record when we're reviewing your testimony. So we'll look for the changes and renew Vickerman 2. So if you could file those by the deadline or rebuttal.
Okay.
That would be good. Just so let's see. So actually, if you could get that, would that be possible to do by Friday? So we can so people will have that number in case they want it.
The exhibit?
Yeah, just the exhibit. Yeah.
Yes, there may be a few boxes that have the word unknown, but
okay.
Yes.
Okay, that's fine. Yeah. So have that by Friday, 1:30.
Okay.
Okay, and I suppose if you are going to change your testimony on pages 14 and 15, that also we'd want to get that in before rebuttal. So we could either do either Friday or Monday. Or page 14 through 15.
Okay.
All right. Okay, the rest is corrections and clarifying questions, just giving you a preview of those. I think that's clarifying. Oh, and so this the last question here, it's just for it's a question I'm planning to ask witness Parrish from the applicant, and it does relate to some extent to this expertise question. And I just wanted to know if we have if someone's going to be able to answer that question for us when we get to the hearing, just in terms of, I think the appendices that I've listed for the application, they say they're filed by, is it TRC, but there's no name, or some documents have a stamp and an engineering number, and license number, things like that, but these are just kind of anonymously filed. So if we could just know who the people were that created those documents, we'd want
So,
to.
Your Honor, can we make that in a Q&A in rebuttal, just to get it out there?
Sure, that's fine. However you want to get it in, that's fine.
So
Yeah.
you're looking for, I mean, as background, what I've done, at least in prior cases, and we didn't do it in this case, was there's an exhibit from the primary consulting witness. In this case, it's TRC, where they've said, which reports are you sponsoring?
Yeah.
And it would have a list like this. But
Mhm.
even in those cases, we did not provide authors or qualifications. From the list that you gave here, and based upon my memory, each of these reports probably has 2 different authors, right? And none of them are witnesses. And so I don't think you're asking for us to bring all those witnesses to this hearing. Just you want to know who they are and what their qualifications are.
That's correct. Yes. So, and just for point of comparison, and this may have been an oversight with the cases that have used TRC that I didn't notice this before, but I do notice, like with Stantec, another expert company that's produced these kinds of documents in other solar cases, their documents will list the authors for all of those documents. And it just gives you a sense of, certainty, or at least the presumption of some certainty as to who authored them. And then just in terms of the party process, it does give people names in terms of who they may want to call, or they want to ask discovery questions of. So just from a procedural perspective, I'm trying to get these cases to be more standardized, and where I saw that Stantec was offering that right off the bat, I just want to align TRC to the same practice. So
Understood. Well,
Okay.
we will get that in rebuttal as a Q&A and probably an exhibit to Jeff Parrish's testimony.
okay, perfect.
Can we go back up, Your Honor? There's a few more questions I have.
Okay, I just wanted to add one more item to this, because it's directly related. So I did notice Ursa Solar's answers to discovery. They also did not indicate who was answering the questions. It just said Ursa Solar. So in the future, if Ursa Solar could indicate, to the extent that you're talking about legal, you may have that in there, who the attorney was, but also in terms of substantive answers, have the person who answered the question named in the response.
Okay. And
Okay.
that's on a going forward basis, not retroactive.
Yeah, let's do it that way. Unless I get a complaint about it. I guess if someone asks you who answered that, you know what to say. But yeah, just going forward, just make that a part of the template.
Understood.
Okay, so go ahead. What else? Yeah.
Thank you. So going to the applicant's witnesses, witness Graham was just the technical edits.
Mhm.
Some of that for witness June is the same. I want to understand what you're asking for on the colored exhibit that you have. Unless I'm missing something, when I look at TON figure B4-1,
Yes.
I don't see those colors, but maybe I'm not looking at it correctly.
You're correct. So I added those colors to ask the question. So what I was looking for is the capacity of each area that's outlined in the color, in each color. So the way I think this represents the hillside, and it shows the panels that are being proposed. And it also shows in red the area that's, I guess, geologically they're not putting panels, or not proposing to put panels there for reasons of topography. So my question is, what's the capacity of each colored section as proposed in the diagram? So I guess you could just like count up each panel. I probably could have done that, but rather than making me guess that, let's have the applicant, provide a number so we can rely on it.
And as I look at this, and I'm sorry, all I can see is the drawing and the marginal note that you have, but there are elements. So like in the blue, you want everything that's circled in blue in there.
Yeah,
That's
right.
how you're. Okay.
Mm-hmm. Yep.
And you're looking for a capacity megawatts AC.
That'll do. Yeah. If I can make this, I don't think I can make it bigger on my current.
Okay, I believe we can do that. I guess if we can't,
Yeah.
I don't see why we couldn't do that.
Mm-hmm.
And this is something you want the witness to come prepared for at the hearing.
Yeah, I think we can wait. I mean, if you want to put it in earlier, that's fine. But if at the end, let me think about that. So if you can put it in rebuttal, it may be clearer to do that, because then you can take this image and, if you want to make it, if you want to format it so that, you can show what exactly you've done, that might be better. So I can give you that. It may be better to do that on rebuttal. I'm willing to leave it for cross or clarification questions. I think we can get the information on the record fine that way, but it just may be cleaner and clearer to do it as a written filing.
Okay, if we'll work off of this map, and if the court has something that can share, I guess that may be helpful. But if not, we can work off of the map that we have in the margins here.
I think I have an original. It doesn't really look much better than that, but at least you can enlarge it and get more specific to the area. So I can send you that original document. Okay. Any other questions about the comments?
So you're asking for extensive analysis by Dr. Loomis in the marginal notes.
I'm asking him to tell us what he knows. So I was expecting these questions to be done on the stand, just to evaluate his understanding of the differences in the reports. So I mean, again, I guess if the applicant wants to address these in writing, it's free to do so. I don't think I'm looking for a detailed answer. I mean, some of these could be, I don't know, and then we can, the commission will know. That's the situation. I don't think I'm not expecting a detailed analysis. I guess I wouldn't prevent one, but I'm not expecting one. So
Understood.
But I mean, I would just take these as being a preview of the questions I would ask at the hearing, so that you're prepared. And yeah, maybe that's a bad thing. Maybe I shouldn't have previewed them this early, because now you feel obligated to provide an analysis. And that wasn't my intention. But I think the basic question is, we have the best has been added. So, what does he think the effect would be if he could tell us on this, as he sits here today on the stand, what would his answer be? The numbers for the different reports, I'm assuming he's using the same analysis, and it looks like the project size is a definite differential. So is there anything else that he can think of that would cause the differences in those numbers outside of the different sizes of the project?
Okay, understood. We'll take a look and figure out the right way to
Okay,
respond, whether it's in pre-filed or on the stand.
okay. All right,
No other questions on this stuff. Thank you.
okay. So anybody else? Comment, questions? Okay, I'll turn off the screen share. Any other questions? Any clarifications that are needed, the refilings? No? All right, well, thank you. We did that in 2 hours, so just an hour over time. Too bad.
Sorry, Your Honor, I do. The link issue and the exhibits can happen after the hearing, like normal refilings. Okay.
Yes, yes, and just do your best. I understand it may not be perfect, so okay, yeah. So and you know, I guess there was another. I can advise. I think it's Lauren Tan on the link issue, because you filed the carbon report. Now I'm losing track of the words. The Wisconsin's
From the governor's office?
yeah, the green energy, whatever, blueprint or whatever we want to call it, but you know what I'm talking about. So I guess we've seen that, we have that report, we've seen it. But what I can say is there's many pages with many links in there, and you don't need to file the whole report. And it would be beneficial actually if you just file the pages of the report that you want to direct the commission to. So if there's a particular section or a particular number of pages, you can refile that exhibit with just those pages, and
Sure.
then you may eliminate like that whole like bibliography section that you'd have to deal with all the links. The only caveat is that when you file a portion of a report, you want a cover page, and then the first page should be the title page of the report, and then you can go on with the selected pages. So a lot of people will forget that cover page, the title page of the report, because we want to know what the report is first. So,
Your Honor, can I be heard on this one?
yeah, go ahead.
Yeah, without having to divulge what our next round of testimony is going to be, not surprisingly, we're responding. And so I would ask the full report be in the docket. Ms. Thomas put it into evidence. We're going to use it as well, not surprisingly. I recognize there's the issue with the links. I don't have an answer for that, but now that she's put this into issue, we'd like the whole document in.
Okay, all right. That's fine. So can we agree just to take the bibliography? There's like a 5-page list of just links, I think, at the end. Since
No
links
objection to that.
Yeah, since links aren't going to be used, you can just keep the link, that bibliography section out. So if you're having trouble with the links, well, you have to refile either way. So on your refile, just eliminate that bibliography section. There may be other links embedded in the other pages, so you just want to go through and check those. And again, just do your best. It's just an extra safety precaution here to keep the record contained. All right, so and that's also after the hearing, those kinds of corrections, please file after the hearing. So I think we just want the TON direct filed at time of rebuttal, and then we have some filings expected from clean and renew prior to rebuttal. So we're all clear with that. All right, anything else? All right, thanks very much. We're adjourned.